The first thing any legal system needs is a set of laws, and I've come to Rochester in Kent to see the earliest known English law code. Established in the 5th century, Kent is thought to have been the first Anglo-Saxon kingdom. Rochester's imposing cathedral and castle testify to the region's historical importance. But Rochester boasts yet another treasure, which for a lawyer such as me is even more significant. Stored in the council archives is a book of enormous importance, not just to the law, but to the entire English-speaking world. This is the Textus Rufensis, or the Rochester Book, and it contains a number of documents, but the most significant is the first, and it's this, a few pages of a text dating back to 600. It's not only the first writing in English that we have, so it's the beginning of English literature. It's the first law code that we have. It's a very simple list of fines or compensation for accidents, injuries, wrongs. If feaxfang ye worth 50 sheata to bote. If hair seizure takes place, 50 sheata as compensation. If eara of worth, a slag. If an ear becomes struck off, one is to compensate with 12 shillings. If one strikes off a thumb, 20 shillings. And this is perhaps the most sensitive one. If someone disables a genital member, one is to buy him off with 3 person payments. A person payment was the monetary value given to a man's life. In this instance, the victim was compensated for the children he would no longer be able to father. We tend to think that the compensation culture is something imported from America. But here it is, at the very start of English law. If laws are the essential basis of any legal system, the next step is setting up institutions to apply them. Courts. Anglo-Saxon society was ordered into areas known as hundreds, so called according to one theory because they may have contained roughly 100 homesteads. These had their own assemblies to deal with minor cases. More serious disputes and crimes were referred up to the shire courts, forerunners of our county courts. This mound goes by the characterful name of Scutcherman Knob, sometimes corrupted to Scotsman's Knob. Anyway, in Anglo-Saxon times, the Shire Court of Berkshire met here, and you couldn't have missed it. Sited prominently on the Ridgeway, assemblies here would have been visible for miles around. Sitting in judgment in the Shire Court might have been a senior cleric, such as a bishop, especially when a dispute involved the church, or otherwise a representative of the king, a figure known as a shire reeve, or sheriff. And trials would be resolved using a remarkably simple method of proof. Early trials were based on oaths. To prove your innocence, all you had to do was to swear an oath that you weren't guilty, and to get people to come here to swear to your honesty. If you could rustle up the prescribed level of support, you were off the hook. Just how many oath helpers you needed depended on your social status and the nature of the alleged offence. One 10th century text
stipulates 36 people were required in a case of arson or murder. To us, it all sounds very odd and open to abuse. But this was a society suffused with religious faith. To lie an oath was to risk damnation, and your friends might be less than keen to support you if they considered you a liability who could compromise their good standing in the community. So yes, it was simple, but that needn't mean it was ineffective or unjust. The Anglo-Saxons didn't distinguish between what we now regard as civil and criminal law, so oaths could be used to resolve property disputes as well. Of course, if two opposing parties swore contradictory oaths, it meant at least one of them was committing perjury, lying on oath. Would this system work now? With their souls at stake, would Anglo-Saxons have been more reluctant to lie than we might be today, when we swear an oath to tell the truth? Some of the best physical evidence for how justice operated in later Anglo-Saxon England has been found on the outskirts of Winchester. The archaeologist Andrew Reynolds took me to Hairstock, close to the old Roman road. What was found here that makes it so special?
Some archaeological excavation uncovered the remains of 16 individuals buried in a series of graves, and the modern name Hairstock is derived from the Old English Llafod Stocan, which literally means heads on stakes. It basically tells us that it's an Anglo-Saxon judicial execution cemetery. So you can imagine here in the Anglo-Saxon period, a traveller moving along the road behind us. We're at a particularly prominent place in the landscape here. You can see this, we're on rising ground. Yes. So a very prominent place, a series of poles with heads on sticks. Very dramatic sight for travellers.
As a lawyer, I put great emphasis on the quality of the evidence. The remains recovered from the Hairstock site are now kept in storage by Winchester museums. Andrew showed me one example of a typical victim.
Now, this is astonishingly well preserved for somebody who has been in the ground 1,000 years. In a layman's eyes, there's nothing here to indicate anything other than the sad death of a young person.
Well, it's a very different picture when the body was actually taken out of the ground, because rather than the hands being to either side as they are here, when the body was excavated, they were found crossed over each other, underneath or behind the back. Now that's a clear indication really that you've got foul play or something that's not quite usual going on there. But the greatest indication that this is not a normal burial is the fact that the head, which you can see here in the correct anatomical position, was actually found by the side of the leg.
This was a clear case of execution by beheading, a punishment not just for committing murder, but theft too.
So how was decapitation done?
Well, almost certainly with a sword, probably with the hands tied behind the back. You take a look at this bone here, where the blade of the sword caught the underside of the jaw when the person's executed.
And that would be one blow, would it?
That would be one blow.
In the absence of a police force, the deterrent for crime was the threat of mutilation or death. Take notice of these heads on stakes, and beware. Like much of Europe, the later Anglo-Saxons developed a way of determining proof which used the power of the elements, of water and of fire, and which invited God himself to intervene in the trial. This was the Judicium Dei, the judgment of God, trial by ordeal. If you were suspected of a crime, you were subjected to a ritualized but painful and dangerous test. God would come to the aid of the innocent, but for the guilty, there would be no such comfort.
The ordeal was neither torture nor punishment. It was a mode of proof. Only if you failed were you punished.
Because of their religious element, ordeals were supervised by the clergy. Two main kinds of ordeal were used in England. The first involved carrying a piece of red-hot iron in your bare hand.
Before the ordeal, the priest called upon God to bless the hot iron, so that it would be a pleasing coolness to those who carry it with justice and fortitude, but a burning fire to the wicked. The accused had to walk a few paces, holding the iron. The hand was then bandaged, and after 3 days was inspected to see if it were healing.
If the wound were clean, that was proof of your innocence. But if it had started to fester, you were deemed guilty. The second kind of ordeal was more dangerous. You were bound and lowered into a body of sanctified water, and your guilt was determined by whether you floated or sank.
Now you might assume that sinking meant you were guilty. After all, you were much more likely to drown. But the belief was that the water was so pure as to repel sin. Sinking indicated innocence. Floating was proof of guilt.
Ordeals like these may seem barbaric to us, but they were carried out in Christian Europe for centuries. I asked legal historian John Hudson what factors determined whether you were sent for ordeal in the first place.
They seem to have been often proposed as a way of settling cases that you couldn't settle in other ways. For example, if you don't have any factual proof, no marks on the person who's accused, no evidence that they're holding on to stolen goods, no blood on their hands, then there's a chance that no one will know who committed the offence, and then the likelihood is that they would have to go to trial by ordeal. The number of people who actually undergo the ordeal, having been threatened with it, may well be much smaller. It seems to be a way of trying to scare people either into confessing or very often into settling.
When the Normans invaded in 1066, they brought with them their own preferred method of ordeal. In trial by combat, God would grant victory to the righteous. This was seen by the wealthy as a more dignified means of resolving civil disputes than hot iron or water. It could also be used in criminal cases.
Good. What was the purpose of the combat? Was it to kill your opponent? Or just bludgeon them into submission?
Well, for a civil case, which would be about large amounts of money or about land, you would probably try to bludgeon them into submission, and one opponent is on the ground and call out, "I yield."
My lord!
Criminal cases were an altogether less dignified affair, often involving the kind of riffraff who couldn't afford a decent blade.
This wooden stick would have been a far more likely weapon in trial by combat in a criminal case. And, in so many words, you try to hit your opponent where it hurts. Head, shoulder, arms, knees, feet, and other male places. Would you like to try?
So I would go like that,
Oh,
or
yes.
that, or boink.
Yes.
And what about that?
Oh, yes, I think so. There is no reason to believe that this wouldn't have been sharpened to a very nasty point, and it may even have had nails in it.
Although it was a trial by combat, it was often hard to distinguish between trial and punishment.
When you beat the opponent to the ground, you might as well carry on and kill them, because afterwards they'll be taken away and get executed anyway, either for the crime they were initially accused of, or if it's the other party that gets beaten to the ground, for having committed major acts of perjury.
What might happen if you lost and survived is told in one of the few accounts of an English judicial duel.
A certain Thomas of Eldersfield near Gloucester was defeated in combat by a man he'd been accused of wounding.
Now, rather than having him hanged, the judges, being merciful, ordered that he merely be castrated and blinded. The victor and his family set about this task with a degree of relish, throwing his eyes on the ground and using his testicles as footballs, the local lads kicking them playfully at the girls. In the reign of Henry II, one important group remained beyond the grasp of the common law: the clergy. Henry's attempts to deal with that problem would come to define his reign and reach a head here in Canterbury. The clergy enjoyed their own legal system, canon law. If you were in holy orders, you were subject solely to the control of the church. The crown couldn't touch you. No matter how serious the crime, a cleric would merely be ordered by his bishop to repent of his sins, whereas a layman might be mutilated or hanged. That is, unless they claimed benefit of clergy. Benefit of clergy provided perhaps the biggest loophole in English legal history. On the flimsiest of grounds, you could claim to be a cleric, thus removing your sanctified soul from the grasp of the secular authorities. Eventually, the benefit could be claimed merely by reciting the first verse of Psalm 51. Have mercy upon me, O God, according to thy loving kindness. According unto the multitude of thy tender mercies, blot out my transgressions. Royal justice was unable to prosecute any member of the clergy who had committed a crime, and this was perhaps the most serious challenge to Henry's authority. So when Henry appointed his close friend, Thomas Becket, as Archbishop of Canterbury, he did so in the hope that under Becket's leadership, the church would conform and cooperate, and those of its clergy who committed serious offences would be subjected to royal justice. But Becket had his own agenda to maintain church authority, and he fell foul of the king, leading Henry to proclaim, "Will no one rid me of this turbulent priest?" What happened next is one of the most famous stories of medieval England. On the night of the 29th of December, 1170, the story goes, Becket was at evening prayer here in Canterbury Cathedral when he was confronted by 4 knights loyal to the king. They struck him down with repeated blows from their swords, and they were so ferocious that they sliced off the crown of his head, so that, in the words of an eyewitness, the blood, white with the brain, and the brain no less red from the blood, dyed the floor of the cathedral. It's unlikely Henry actually ordered Becket's murder. His archbishop's death undermined all that the king wanted, as public opinion rallied round the church. Becket became a martyr, and a repentant Henry felt he could no longer touch the issue of priests who had broken the law. It would take centuries before the clergy were subject to the secular law, and as for benefit of clergy, that would not be abolished until 1827. The reign of Henry II witnessed a profound change in the development of English justice. The king himself introduced a unified legal system for the whole country, a common law. He also presided over the development of the jury. Early in his reign, Henry had already established a system of roving royal justices what we would now refer to as judges, who travelled the country ensuring this common law was being enforced by each and every shire court, and claiming all the fines that were due to the king. Now, Henry went one step further, decreeing that members of the public should play an essential role in this legal process. These so-called juries of presentment soon became common practice. Juries of presentment didn't consider evidence and determine guilt or innocence. Instead, they were representatives of local communities who had to report under oath all the crimes committed in their area and to name those they deemed responsible. The gradual emergence of this new system received an unexpected boost when suddenly, in 1215, Pope Innocent III banned the clergy from presiding over trials by ordeal, effectively withdrawing the church from the legal process. Now it was no longer the Almighty, but a rather less exalted tribunal that would determine the outcome. The judge would ask the members of the jury, when declaring whether the accused were guilty or not, to give a truthful answer. In the Anglo-French of the time, a verdict, our verdict. The first known English jury trial took place in 1220. A woman called Alice, condemned for murder, accused 5 others of criminality. They chose the judgment of their neighbours, in the phrase of the time, putting themselves for good and ill upon a verdict. These neighbours decided that 1 man was lawful, but that 4 were thieves, and they were sent to the noose. By the late 13th century, such juries had become a familiar part of English law. Unlike modern ones, they didn't weigh evidence, but came to a decision based on their own knowledge or belief. For ordinary people to have such power in a society that was, in other respects, full of inequalities, was revolutionary. Your peers had been given an authority that had previously been the preserve of God. Your guilt was now decided in public by members of the public, independent of the state. The jury, the institution that most defines English justice, truly begins here. In the mid-17th century, in the years leading up to the Civil War, England had a 2-tier legal system: the common law and a system under royal authority, which allowed torture and enabled the king to do as he saw fit. Its court was held in the now notorious Star Chamber. Near where I am standing was the site of the Court of Star Chamber, today a byword for injustice and oppression. But in its inception, and throughout most of its history, it represented precisely the opposite. Star Chamber came to the forefront during the reign of Henry VII, after the Wars of the Roses, a time of great turmoil in Tudor England, when nobles ran their territories like mafia bosses, and disputes could end in what we would now call contract killings. The nobility seemed beyond the law. They could intimidate juries and bribe judges. So the Crown developed a court outside the normal common law. It had powers that could break this English mafia. No amount of money could buy this court, and soon the previously untouchable nobles found themselves in the dock. It may look like an upmarket country pub, but this was where England's most powerful men clashed. Justice was dispensed under this ceiling of gold stars, from which the court gets its name, Star Chamber. It had no jury that could be bribed or intimidated by the mighty. Instead,
errant aristocrats were interrogated and judged by members of the government itself.
The power of Star Chamber grew considerably under the Stuarts, but by the time of Charles I, it was widely recognized as a symbol of misuse and of the abuse of power by the king and his circle. In 1629, Charles dismissed Parliament and took control of the country in what is now known as the 11 Years' Tyranny. During this period, Charles used Star Chamber to raise taxes by fining the wealthy and petty charges, but also to clamp down on religious dissent and political opposition.
Under this ceiling studded with stars, disfiguring and degrading punishments were imposed by cruelly imaginative judges, the creatures of the king. The victims of such treatment were those bold or rash enough openly to oppose Charles's arbitrary rule. Some had their noses slit, others their ears cut off. Public displays of royal displeasure. Those reluctant to incriminate themselves or others might be persuaded to change their minds by a trip to the Tower.
It was home to the rack. Bridget Clifford from the Royal Armouries revealed the Tower's dark secret.
For the poor unfortunates upon which this was used, what would have been the procedure?
You would be set upon it. The ropes would be applied to your ankles and to your wrists, and then it would be slowly tightened by rotating the drum.
One master of the rack was said to have boasted of racking a prisoner 1 good foot longer than even God made him.
What allegations or offences would this have been applied to?
Mainly treason. Now, what constitutes that threat can be a physical threat. It can also be the fact that your religion is seen to be standing against that the country approves of at the time.
For over a decade, Parliament's doors were locked. The king ruled alone and supreme. These dark days remained until a costly religious war with the Scots drained the royal finances. Finally, in 1640, Charles was forced to recall Parliament to get money. Now back in the game, the MPs aimed to destroy the hated institution of Charles's rule. Torture warrants were made illegal. No attempt to revive them has ever been made since. And the victims of Star Chamber, those who had lost money, liberty, or ears, called on Parliament to rein in this other symbol of royal absolutism. But they didn't just rein it in. On July the 5th, 1641, Charles was forced to sign Star Chamber out of existence.
I'm here in the Parliamentary Archives to see a document devised and drafted largely by Edward Coke, and whose significance to our constitutional history is second only perhaps to that of Magna Carta itself. It is the Petition of Right.
Edward Coke, the driving force behind the Petition of Right, was perhaps the most influential judicial figure of his time. During the reigns of James I and Charles I, Coke had bravely fought for the supremacy of the common law over the power of the monarchy.
So here it is, the Petition of Right itself. Now, it may not look a great deal. It's a piece of vellum with a
a lot of rather nicely written words on them. But of course, its significance is far more than just the document we have before us. It's only one page, but it helped change the course of history. It's hardly a humble petition, but that's how it's phrased. Humbly do the Commons point out to the King the law of the land, what had always been, the civil liberties, the liberties of the subject, enshrined by parliamentary statute. And then they go on to the meat of the complaint, that despite all these enactments in the past, things have gone horribly wrong, and in particular, divers of His Majesty's subjects had of late been imprisoned, and when they were brought before His Majesty's courts to challenge the conditions of their detention, they were denied justice, and they were sent back to prison without cause.
Edward Coke was clear this would never happen again, insisting
that no man hereafter be compelled to pay taxes without parliamentary authority, or be imprisoned without cause.
any individual who was imprisoned could demand that their jailer legally justify their actions. This idea, central to our liberty, is known as habeas corpus. It was a principle whose power would grow immensely over subsequent decades. Coke's ideals were even incorporated into the Constitution of the United States of America, a descendant of the Petition of Right itself.
This is a document that is not just significant in 17th century England. This is a document that is one of the foundation documents of civil liberties.
In the space of 1,000 years, the law had evolved from being a rough code to settle local disputes in Anglo-Saxon England into an independent institution, so powerful that it was capable of killing the King of England. Charles I and the monarchy had been swept aside. But in 1649, there was a fear that England had simply swapped one tyrannical regime for another. In an attempt to impose order in the chaos unleashed by the Civil War, Oliver Cromwell himself was stamping down on dissenters, whether religious groups like Ranters or political movements like the Levellers. Radical groups could no longer look to Parliament to uphold the law in the cause of liberty. Individuals would have to deploy the law themselves, and none more so than the leading leveller, John Lilburne. He believed that the time had now come for all the men of England to claim their ancient liberties. He exploited the power of the printing press to secretly publish and distribute his radical views, which quickly came to infuriate the authorities. They'd repeatedly lock him up to shut him up, but Lilburne had a crucial legal weapon on his side, habeas corpus, and he thought that this piece of paper could be his key to freedom. Here's how habeas corpus works in practice. A document known as a writ is delivered to the jailer saying, "We direct you to have the body," habeas corpus in Latin, of, say, Harry Potter, before this court, along with the reason for detention. If the jailer cannot satisfy the court that the reason is lawful, then Harry Potter walks free. Habeas corpus is a remedy against arbitrary arrest and unlawful imprisonment. Lilburne employed habeas corpus more often than anyone in history. The results were more symbolic than actual. He was able to highlight his predicament and embarrass the authorities. Yet he'd still be sent back to jail. If anything showed how the law was being challenged, it was this. In March 1649, Lilburne's latest pamphlet attacking Cromwell's regime got him arrested. While he was being held, Parliament created a new law. It made it treasonable to call the government tyrannical or unlawful in print. A mutiny in Oxfordshire brought things to a head. Lowburn's pamphlets were blamed for goading the troops to revolt. Cromwell put Lowburn on trial for publishing seditious pamphlets under this convenient new treason law. Cromwell then left for Ireland, safe in the knowledge that Lowburn was all but a dead man. But Lowburn was no fool, and equipped with an astounding knowledge of current legal practices, he took delight in defending himself. Throughout the trial, he skillfully undermined the legitimacy of the court, refusing to call the presiding judge Lord President, but also by requesting numerous comfort breaks due to his prolonged period of standing in the dock. Astonishingly, the court allowed him to have a chamber pot, which Lowburn then duly used in front of the jury. Lowburn had mounted an impassioned defence few barristers could better today. How would the jury react? Finally, the foreman announced him not guilty. His life was saved, and the cheers from his supporters lasted over half an hour.
At his trial, Lowburn won important rights: the right to a vigorous self-defence, to challenge seeming unfairness in court procedures, and to take comfort breaks.
Lowburn had woven the law into a safety net that ensured Parliament couldn't silence him. Now, just as Charles I had used Star Chamber, Cromwell needed to find a way of dealing with Lowburn outside the normal parameters of the legal system. The next time Lowburn stepped out of line, Cromwell would have something up his sleeve. Before he could issue a writ of habeas corpus, Lowburn was shipped across the English Channel, beyond the reach of the law. On this offshore military outpost, the normal protections of English law were almost impossible to employ. Jersey was Oliver Cromwell's Guantanamo Bay. Lowburn's extraordinary rendition took him from the relative comfort of the Tower to here, Mont Orgueil Castle.
Cromwell wasn't prepared to take any more chances with a man like John Lowburn and dispatched him here to Jersey. Isolated on an island, out of sight and out of mind, he was beyond the effective reach of habeas corpus.
Castle curator Doug Ford gave me a much warmer welcome than Lowburn received.
So this is Lowburn's cell?
This is Lowburn's cell, yeah, it's his bedchamber. From the 1640s through to the 1660s, this is where important prisoners were lodged.
Though in the summer it's still quite chilly, and I notice the walls look and feel damp.
Yes, we're very exposed up here at the top of the cliff.
Lowburn was offered his freedom if he would just stop agitating against the government. But being Lowburn, he would not back down. A year's imprisonment in the conditions of this castle, however, if it couldn't destroy his spirit, left him a largely broken man. In 1657, only 2 years after he was released, John Lowburn died, aged 42. But habeas corpus lives on to this day. With the restoration of the English monarchy in 1660, Charles II resumed the Stuarts' favourite family pastime, religious persecution. A new law targeted religions outside the Church of England. It severely restricted all nonconformist worship. The Conventicle Act banned any assembly of more than 5 non-Anglicans. Thousands were prosecuted under the Act: Catholics, Presbyterians, Quakers, and those found guilty were subject to imprisonment or even transportation. But that didn't stop 2 gutsy Quakers defying the law. William Mead and William Penn had not just broken the rule of 5, they'd been addressing a crowd of hundreds when they were arrested. But although they were guilty by the letter of the law, many Englishmen felt the law was morally wrong. And luckily for the defendants, 4 of them were on the jury. These 4 jurymen, led by a merchant called Edward Bushell, bravely declined to find the defendants guilty of a criminal offence. The furious judge called Bushell impudent and threatened to put his mark on him. But Bushell held firm, and soon the remainder of the jury followed suit. Their verdict was not guilty. When the jury failed to bring in the right verdict, the judge shut them up without meat or drink, fire or tobacco, to reconsider their decision, or to starve. The conditions in Newgate jail were so bad that 1 in 10 prisoners died there. But habeas corpus was waiting to strike again. Edward Bushell managed to get a writ heard before Chief Justice Vaughan. The case had become infamous, and Westminster Hall was hanging on Vaughan's decision. What happened next would have a lasting legal impact. I asked the current Lord Chief Justice, the highest judge in the land, about Vaughan's ruling.
And he declared that juries should return verdicts in accordance with their conscience, and that no juror should ever be punished for the verdict that he reached.
How significant was the case of Edward Bushell?
It was absolutely crucial. This was a remarkable moment in our history. The Chief Justice Vaughan made it absolutely plain that that was the end of any possibility of a juryman being punished for his verdict. And it never happened again, and never has.
The jury were finally freed, but only after spending several weeks in England's most notorious jail. Today, juries are free to give their verdict without repercussions, no matter how perverse it appears to a judge. (1771). The Thames docks. A legal document is raced down to a ship that is about to set sail with its cargo for Jamaica. The document required the ship's captain to produce his cargo before the Chief Justice. The document was a writ of habeas corpus. The cargo, a slave called James Somerset. By putting Somerset in chains, the ship's captain had become his jailer, answerable to the law. Habeas corpus gives a prisoner the power to compel his jailer to justify his detention. A realization swept across the slave trade. The very legality of slavery itself was going to be tested in court. So who was James Somerset, and how had he come to be here? I asked Arthur Torrington, who has studied the history of slavery.
I suppose cousin. James Somerset was kidnapped and taken to Virginia. He was bought by a gentleman by the name of Charles Stewart. A boy of 9, enslaved, was just a page boy, was just a helper. But eventually, about 10 or so years after, this Mr. Stewart brought him to London, and that's when all the things began to change.
James Somerset escaped. Frightened and in a strange land, he sought refuge in London's 15,000-strong black community. And when the leading slavery abolitionist Granville Sharp heard of Somerset's plight, he knew he had found the perfect case with which to test the very legality of slavery.
In the case of Granville Sharp, he felt that these are human, and therefore these are human beings that cannot be and should not be treated in that particular way, in which they are enslaved, they are not given human rights, and so on. So Sharp was determined to break that cycle if he could.
This was an argument about whether a slave had rights on British soil. Did the law regard slaves as property? If so, a writ of habeas corpus would be meaningless. Or would the law see slaves as human beings? If so, habeas corpus could challenge their transportation out of the country. Ultimately, the judgment in this case would reverberate across the entire slave trade on both sides of the Atlantic. The case went to the very top, to Lord Mansfield. The slave traders could have expected Mansfield to be their ally. Of Scottish noble birth, he embodied the establishment. From his imposing home, Kenwood House, to his rulings embracing free trade, he had been prominent in both Houses of Parliament and was the highest judge in the land, Lord Chief Justice. As the case ground on in Westminster Hall, Lord Mansfield is said to have proclaimed, "Let justice be done, though the heavens fall." Both sides were well represented. The abolitionist barristers claimed that there was no law legalizing slavery in this country, and so it must be illegal. The Slavers' Council countered by saying that as contracts for the sale of slaves were recognized in English law, that must validate slavery in England. The court adjourned for Lord Mansfield to prepare his judgment. Mansfield brooded over the case. What did the law say? What did his heart say? What impact would a ruling on the James Somerset case have? Granville Sharp, the great abolitionist, was anxiously awaiting the ruling. But having clashed with Mansfield in the past, he didn't come to court to avoid antagonizing the judge. So he didn't hear the judgment delivered, staying instead at his home. The result was sprinted through the streets to him. In this street, somewhere near that spot, Granville Sharp answered his door. There in front of him, smiling, exultant, stood James Somerset, a free man. In his judgment, Lord Mansfield said that the state of slavery is of such a nature, so odious, that the English common law could never accept it. Now, whether he meant by this to ignite a spark that would end slavery is unclear, but that is how his judgment was interpreted both here and abroad. One single writ of habeas corpus had released not just one man from bondage, but was to mark the start of freedom for all the 15,000 slaves then in England. At the start of the 18th century, our liberties and freedoms had been established. The courts, by comparison, were still in the Dark Ages. Land yourself in the dock, and you found yourself in a medieval nightmare. With no police force and no forensic science service, the only means of deterring crime was through exemplary punishment: whipping, transportation, and hanging. And an already severe system was about to get even bloodier. This is Waltham in Hampshire. In 1723, it was a place of terror. A gang rampaged through these forests, poaching, robbing, and murdering, their faces blacked up in disguise. It was feared these Waltham Blacks, as they were known, would spread their violence across England. As a knee-jerk reaction, the Waltham Black Act was rushed into law. Suddenly, all manner of offences were punishable by death. Just being caught in a park with a blacked-up face could get you hanged, along with damaging trees and wrecking fish ponds. It was the harshest piece of legislation that the country had ever seen. Thus began a terrible trend that meant that by the end of the century, more than 200 offences were punishable by death. Deterrence was all. As Judge Buller told a felon he was sentencing, "You are to be hanged, not for stealing horses, but that horses may not be stolen." This system was appropriately named the Bloody Code. In this era, people felt the innocent should be able to argue their own cases.
Many an accused, when compelled to defend themselves in this alien environment with its unfamiliar procedures and terminology, would have been terrified into incoherence when their lives were hanging in the balance.
If the defendant needed assistance, the judge was expected to offer it. With the judge your only defender, and the Bloody Code sanctioning hanging for over 200 crimes, you might have expected the hangman to have been the busiest tradesman in town. Thankfully, something came between you and the noose: the jury.
Juries were considerably less punitive 200 years ago than perhaps you might think. When faced with a bloody code which imposed the death penalty for innumerable petty offences, juries were inclined to go against their oath of bringing in a true verdict, and either to find people not guilty, or more often to reduce the amount of property stolen so that it was no longer a capital offence. This was known as pious perjury. And let me give you an example. Here's just one case from the Old Bailey records, and it relates to a Mary Bain of the parish of St Andrew, Holborn. Now, she was indicted for the theft of clothing worth over 50 shillings. That was a capital offence. She made a frivolous defence, upon which the jury found her guilty to the value of 4 shillings and 10 pence, thus rendering her no longer liable to execution, and so she was merely branded.
During the 18th century, the whole system of law and punishment that had come to be known as the Bloody Code wasn't working. It was savage and disordered, and needed a major overhaul. And only the government could do this. There was a politician with the courage, the obsessive eye for detail, and the power of personality to take on this project: Robert Peel. When Robert Peel became Home Secretary, there were over 100 statutes dealing with forgery alone. He ruthlessly attacked this legislative mess. Out of this bonfire of legislation, Peel pulled a piece of legislative magic. 120 statutes were transformed into one, just 6 pages long. With consummate skill, Robert Peel did more to reform the criminal justice system than almost any other Home Secretary. Over the course of 8 years, Peel consolidated 3/4 of all offences into a few key acts. The Waltham Black Act, with its dozens of hanging crimes, all but disappeared. The death penalty was severely restricted. Peel had reformed the law. Now he searched for the means to enforce it. The Bloody Code's unjust punishments had failed to reduce crime. Could there be a better deterrent? In August 2011, rioting swept England. and for a time the mob ruled. Eventually the police controlled the situation, but imagine the destruction if, as in Robert Peel's day, the police didn't exist. Instead of deploying police and employing water cannon, governments relied on the Riot Act. The Act held that where 12 or more people gathered together in riotous assembly and rejected the reading of the Riot Act and failed to disperse within an hour, then force could be used against them. Those remaining on the scene would be subject to the most severe penalty of all, death. Riots were frequent, and to restore order, the only option was to send in the army. Robert Peel's new idea was to create a police force. Uncontroversial to us, but at the time, a radical and suspect concept.
I think he was quite clearly looking for the right answer.
I asked former Home Secretary Douglas Hurd about the reaction to Peel's innovation.
Why were people opposed to the creation of a police force?
Because one of the themes which run through English history in the 18th and 19th century is the fear of a standing army. The standing army was thought of as something the Stuarts rather believed in, because it was a sort of reinforcement of royal power. And people thought, and this was very strong when Peel first produced the plan for a metropolitan police, that this was just the government trying to grab hold of the lives of the people.
Peel had long sought to replace the existing and ineffective system of night watchmen and parish constables, but he faced an uphill struggle in the face of the argument that a professional police force would be a danger to liberty. Could Robert Peel convince the population that having a police force did not mean England would become a police state? In 1829, he did this by persuading the public that the police would not just control people, they would primarily control crime. "I want to teach people," wrote Peel, "that liberty does not consist in having your house robbed by organised gangs of thieves or leaving the principal streets of London in the nightly possession of drunken women or vagabonds." Crucially for English criminal law, the creation of a professional force meant that the police, rather than harsh penalties, became the main deterrent of crime. The long arm of the law would prove far more effective than the noose.